This is the so-called political panel to discuss the data protection reform. We hope to shed light today on the key actors, constellations, and drivers affecting further progress. We've taken the questions that were on the website and put them there so you can see them. And the idea is to have short interventions from the panelists and then driven by the moderator, a nice discussion of each point. I'm the chair today. My name's Docksey. I'm the director of the EDPS, the European Data Protection Authority. We've stolen the logo for this presentation. You remember that the reform was launched in, the communication was launched in 2010, package in 2012, and then an awful lot has happened since the last CPDP in January 2013. And over all this period, Nikolaj Nielsen, here on my left, has been writing on these developments for the EU Observer website. Nikolaj has won awards as a European journalist, and today he is our moderator. Welcome, Nikolaj.
Thank you.
In 2013, first we had a sort of feeding frenzy by consultants, which resulted in the famous 4,000-odd amendments by MEPs to the data protection package. Many of these amendments were aimed at watering down not just the new proposals, but even the existing legislation. My own personal favorite was pseudonymization, if I can pronounce it. The feeding frenzy slowed down a bit after the summer and after the Snowden revelations as of June onwards. Anna Fielder, who's on my left, who's chair of the board of Privacy International, has been following this and will provide some interesting insights. Anna is not just a privacy person, but she's also a consumer protection expert. And that combination, I think, deserves great attention from the privacy community. In October of 2013, the LIBE committee approved a substantial upgrade, if I dare say that in front of my colleague from the Commission, to the Commission proposals. Indeed, it achieved this by an absolutely stunning majority vote. The committee restored text that had been deleted at the final stage of the internal Commission drafting process, and it proposed a lot of workable solutions to intractable problems such as thresholds and sanctions. Now, Wojciech Wiewiórowski, who's here on my right, is the head of the Polish Data Protection Authority, the GIODO. Wojciech is one of the few privacy people, I think, who actually understands the tech side of it. And as well as being a regulator, he is also an observer at the Council of Ministers, the DPAs. And so he'll be able to give us some insights on what is happening inside the Council. I did suspect in 2013, once the lobbying had slowed down, whether people would say, gosh, if we can't water it down, maybe we should slow it down. And that's exactly what happened 4 days after the LIBE vote. In the Council of Ministers, there was a push to slow down the whole thing, to set a date for 2015, or even not set a deadline at all. But fortunately, the people who wrote the conclusions of the European Council took a lofty view of the discussions and shifted the emphasis to completing the digital market by 2015. And the Commission has interpreted that to mean that the reform has to be adopted by April, if we are going to actually contribute to the digital single market in 2015. I like this interpretation. I hope the DPAs working party of the Council is equally convinced. Philippos Mittleton, who's here on my right, is a senior lawyer in the Greek Data Protection Authority. And Philippos is on loan to the Council of Ministers, as I understand it, to advise the presidency on the reform process. And so Philippos will give you a real good insight into the presidency's plans. Lastly, in December of last year, we were treated to an exciting legal opinion by the Council Legal Service. It warned that the proposal to set up a one-stop shop was too complicated, to the extent it could be contrary to the right to an effective remedy. The Commission was very unhappy. Its legal service produced an opinion saying exactly the opposite. So just before Christmas, we were faced with legal deadlock at a time when we should have been racing towards agreement between the Council and the Parliament. Now, Paul Nemitz, who's here to my left, is Director of Fundamental Rights and Data Protection in DG Justice in the Commission, and I'm sure he has strong views on this part of the process in particular. At this point, I think I should pass the floor to Nikolaj and get the debate going.
Right, thanks. I think I'm just going to launch right into it. And before we start on the questions you see up there, if I could ask each one of the panelists what they think are the most important issues for their part concerning the data protection regulation. If I could start with Anna, please.
Is this on? Yes. Well, first of all, thank you very much to the organizers for inviting civil society here and for giving me the great honor of speaking first. I'm sure my learned friends on my right will have much more important things to say. And if you're asking me what are the most important issues to us to begin this important debate, just to make a little disclaimer, I spent yesterday and today asking colleagues from all civil society organizations on their thoughts because I thought it was important for me to transmit not just Privacy International or my personal opinion, but the opinion of my colleagues in civil society, and we have been working very closely with European digital rights on this agenda for the last 3 years. So I'm not just speaking for myself. If you're asking me in an essentialist sense what the most important things are to us as a civil society, I would say to you that we want a simple, effective, easy to understand piece of legislation that you can serve to ordinary people in the street and they will understand what it is all about. This is unfortunately not happening, and however much we applaud the final Libe vote, it has resulted in even more confusion than there was before. Just to give you an example, with a legitimate interest compromise clause, I gave it to 2 of our lawyers, one reputable international lawyer and another one a lawyer in PI, and they both gave me completely different interpretations on the clause. So that's clearly a very serious problem. Maybe it could be rationalized and simplified in the Council, but one of the key demands from the civil society are get on with it, make an effective, simple regulation, make sure the data subject rights are there and respected, and make it so that ordinary people can understand what this regulation is about. So that's as an introductory bit. I'll answer the next questions in more detail.
Okay. Can we pass it on? Yes, Mr. Nemetz.
Yes, thank you very much. I think the most important thing now is closure. If the European Parliament can agree with a very broad majority across all important parties on a reasonably good text, then I would say the Council should also be able to do it. And to come back to a formulation of Chris Docksey on the interpretation of the European Council conclusion and how DPAs would interpret it. Well, I think that's beyond the pay grade of DPAs. And this is part of the problem of this file. We now need politicians, we need ministers to take charge. And we have to inject the normal legislative political wisdom into the debate, which is this: no law is perfect. No law solves all issues one can think about. And indeed, that you have 3 lawyers and 4 opinions is also normal relating to laws on the books. So let's get beyond the perfectionism which some use to stall the process. Let's recognize that we need a regulation which is better than the directive we have right now, which is directly applicable, one law which creates more legal certainty by being a regulation rather than a directive. Let's get beyond the bickering and do what industry in Europe needs for growth, which is to create legal certainty. Let's give DPAs more instruments to become real enforcement agencies rather than well, some say, you know, a club of gentlemen and gentlewomen who meet once in Warsaw and next year in Mauritius to discuss important issues. Let's equip them to become real enforcement authorities, and let's get this law on the books, which also increases the control of the individual over his or her data. This file has a synergy between protection of individuals and a high level of protection of individuals and their fundamental rights and growth. Because only if we install trust and reinstall trust of individuals that their data will not be abused, the growth potential which we have in Europe in all industries, not only in the digital industries, will be realized. And so we have here no contradiction, we have a synergy. Let's make now use of it, let's take political charge and bring this to closure, and the European Parliament must be applauded for the fact that they have done the decisive first step. Now the move is up to the Council.
Thank you. And we'll hand it on over to Mr. Mittleton, please. Thank you.
Use this?
That's okay.
Yep.
Okay, thank you very much. First of all, I wanted to thank the organizers of the meeting for inviting me in order to present to you the position of the Greek presidency on this issue. Before I try to explain what are the main issues in this context, I would like to begin with some very short introduction. With one introductory remark. Greece just took over the presidency in a, if I may so, triply difficult context. It's difficult for Greece because of the economic crisis, as you can understand, that it has side social and political effects. It's difficult for European Union since we are in a crossroad. We have the parliamentary elections in May. We will have a new parliament. We will soon have also a new commission. So it is a difficult context for European Union, and it is difficult also for data protection, because as you know, after the latest revelations about NSA, PRISM, and the mass surveillance, data protection is a top priority, of course, in the concern of the people, etc. So I think that in this difficult context, Europe needs to have a coherent, comprehensive, and effective data protection framework. So I think this is very important. Of course, there are a lot of problems at technical level. There are a lot of concerns from the member states that have either technical or legal or political even dimensions. But I think that it is essential to try to go on and achieve a level of consensus that will enable us to have such coherent and a coherent legal framework that functions and protects the rights of the individuals in the European Union. That's my first.
And Mr. Wojciech?
Could you take the glasses under danger? Okay. Thank you very much. I tried to say the things from the position I have at the moment as a data protection authority in Poland, but also as a person who is taking part in the activities with the reform, also on the level of DPAs. Polish Data Protection Authority is an expert body to the governmental authorities which are taking floor at the DPAs meetings, but we are generally present at the DPAs meetings, and we are observing what's going on there as well. Well, if we meet a year ago in January 2013, my introductory remarks would be exactly the same as Paul Nimitz's. I would absolutely agree with what Paul said and what are the demands for the 2013. But after 2013, I actually have to change my mind, and I have to change my position on what actually is going on. We had this point when LIBE committee has done really a great job preparing the result out of 4,000 amendments. We can sometimes disagree with parts of the things that was done there, but I have to say I really admire the work that was done in the parliament, because I never expected that they can go out of these 4,000 amendments with the agreement of all the parties in the parliament. So once they were left alone, let's say, with all these 4,000 amendments and the text that was provided by the Commission, they could do something out of that. Unfortunately, this is not true with the Council, as you precisely know. And while I agree with Paul Nemitz that this political will and the political decisions were expected in 2013, Commissioner Reding has done everything to achieve them. We didn't achieve them. We didn't because actually there was a big failure in explanation of what really the reform is all about. And I'm saying it as the representative of the DPA, who was always very supportive towards the regulation, also supported towards the directive, the third pillar directive. And we managed to convince the government in Poland to be supportive as well. Those of you who heard Minister Boni at the international conference in Warsaw saw that he was really pushing towards the new regulation to be adopted as soon as possible. When he stepped down for personal reasons in December, the new minister responsible for that is the member of the European Parliament who was taking part in this LIBE agreement. If we had a member of the European Parliament who was really involved in the reform, that was Minister Trzaskowski, and he's right now the minister responsible for that also in the Council. But unfortunately, I have to say that after all these discussions we had in DAPIX throughout 2013, we are losing the allies for the regulations. And Poland is probably one of the last allies that is now that the Commission is now losing. And that's definitely the failure of the Commission to explain to the Council what actually is on practical level, not the political level, not the level of the big words, but the level of real legal rules that are in the regulation, what is really the thing to be achieved. And, well, I'm sorry to say it, but Paul, you are very open always to say what should be the role of the DPA. What should not be the role of the DPA, what we should do, what we should not do. You did it also yesterday during the meeting in the permanent representation of the Republic of Poland. So let me say what the Commission should do. The Commission should support its own project, its own draft. And unfortunately, it was not able to do it. When we were coming back from the discussion in the Council, the main impression was surprise and at least disappointment of what we had. And what we didn't hear, no answers or the non-precise answers to the question that were asked by the government. And unfortunately, to say that there's the political will who should solve it is definitely not enough. So these are the things to be done in Justus Lupsius building of the Council, not on Twitter. That's not the way we should create the legal acts. We should create them at the Council, and that's the thing which was not done well, not by the countries, but by those who should actually support the draft. So I have to say that I'm disappointed, and in my opinion, we are facing the very difficult year of 2014, which probably will not finish with a good result.
Before I would like to kind of also open this up to the debate with the public, but I think this kind of ties into the very first question that's on the list here. It sounds like to me that what you're saying is one of the main actors in delaying this is also the European Commission. And I was wondering if Mr. Nemitz would like to respond to that.
Well, I think, first of all, the fact that the Parliament has been able to agree, and of course it has agreed with a lot of explanations, based on a lot of explanations the Commission gave, and we have worked very closely with the rapporteurs and the shadow rapporteurs, shows that there is one legislative body who would not share this analysis which we have just heard. I think if you ask the rapporteurs, they were very content with the explanations we gave. And of course, in the Parliament, we have done what we have to do also between the institutions and also in the Council. We have made suggestions and brokered compromises where we saw middle lines. And that is the job of the Commission in this phase. And in the Parliament, we were successful because wisdom, political wisdom, politically guided judgment ruled. You know, turning to the Council, I can just say, you know, the commentary, the legal commentary on data protection of 2,000 pages, which Bureau Semitis wrote in Germany, it will appear anyway. It doesn't matter how long the Council negotiates, there will always be questions which remain open. You know, the world cannot be ended, technological progress, business model progress cannot be ended by law. And so I think what we are facing is a complex material, but there's much legislation in the Parliament, in the Council, which is complex. And we're facing a clear political orientation by the European Council, 2015, as the target date for functioning internal digital market. And to this, we need to work together with reason and not with absolutist, perfectionist standards, which can never be reached in legislation to get to closure. Honestly, we do what we have done in Parliament, also in the Council, but regularly new issues, new problems are invented, and I don't see any technical problem in this regulation which cannot be overcome if there is the political will. What is on the table now is progress, and it is not perfection, but there is no perfection in legislation in democratic countries, because by the very nature of things, one needs to make compromises, and therefore my wish is that member states, rather than focusing on one solution on this and that, define for them corridors of the acceptable. Corridors of the acceptable. I think this is where we need to come to compromises which can be carried by the necessary majorities.
I think Anna wants to step in on this one.
So I don't disagree in principle that if there is a political will and the will to progress, it can be achieved and we can have closure. But the European Parliament, I disagree with you on the point of the European Parliament having the political will. What they had was two very speeding elements. One was the elections coming up in the spring that can speed up, you know, anybody. And the second, I think the mass surveillance revelations had a very big impact, both on the speed of the Parliament, but also on the sort of intensity of the lobbying. It had a massive impact on the industry because they realized they suddenly have this big trust and public relations issue, and they had to do something about it. So the results we had in Parliament were very much to do with all these externalities as well. And it had an impact on the Commission because for the first time in X years, the Commission decided to investigate issues like safe harbour properly, despite our calls to do so before. It didn't do that until the last moment, and it confirmed all the things civil society has been saying for years, that it's not working, that it's got faults, and you know, it's got a big impact on data transfer. So there are other externalities as well. Whereas the Council, of course, has completely different motivations. They don't have elections, they have to work on the ground, they have sovereignty issues, they have the economic crisis issues, how much money this is going to cost them. You know, as we know, the UK ICO would lose its funding through the new regulations, so that has a big impact on how, for example, the UK is reacting. So the motivations are different, and you know, the Council have different expertise coming to bear, like, you know, we heard from the Polish DPA. So I think that if you talk in terms of influences and delaying, the situation is much more complex.
And Mr. Mittleton, yes, I had a question for you about actors. I mean, you're in charge of steering the negotiations for the council, but I mean, you have some member states like the UK, Denmark, Hungary, and Slovenia that basically don't want a regulation, they want a directive. I mean, given these kind of obstacles, how do you feel confident that you're going to wrap this up by the end of your presidency, or are we going to see this in the Italian one as well?
Well, look, this is, it's true that it's a very difficult task to put everything together. I mean, the Greek presidency's task in DPAs is very delicate because we want to achieve a result that can be visible, okay? And that can be effective, and that can be used by European citizens and people that live and work in the European Union, that can be useful also for the market, for the companies, that could be useful for the governments, okay? But of course, it is very difficult to try to, I mean, we understand the concerns of the members of some member states. I wouldn't like, given my position as a representative of the presidency in DPAs to name member states, but I understand that there are some very important concerns that have to be met, and our task is very difficult in order to try to redraft the different chapters or provisions, everything, in order to meet the concerns of the member states and try to present a comprehensive output. Okay, probably it's not only my personal opinion, but it's also the view of the Greek presidency. I mean, I cannot understand how such an important legal instrument as it is the package, regulation and directive, that has been examined and we have worked on it. I mean, the Commission and everybody has worked on it all these years. I cannot understand how can we say that after all these years we cannot arrive to a result that can be effective, you see? I mean, to a result that cannot be, on which we cannot have a political agreement. I mean, this is really strange, okay? Mm-hmm. So, of course I recognize the very good work done by the Parliament and the Libe Committee, but the feedback that we have is that also the Parliament wants to have a visible result before the end of its session this year. So I know that it's very hard to do that. It's a difficult task, but we have to try to achieve the constructive support of the member states. Okay.
Okay. And I just wanted to go back to Mr. Wojciech. You had spoken about how Poland, well, basically might no longer be an ally in this debate when it comes to the package. What kind of scenarios do you foresee? I mean, good and bad.
Well, several scenarios that can be taken into consideration. Let me say just about two of them. The most positive for me and the most negative for me. Well, the most positive, which is highly doubtful, but I'm still trying to believe in it, is the fact that, first information at the beginning. I don't believe the package will be done before the elections of the European Parliament, okay? Full stop. There is no possibility to do that. So this scenario does not exist. But the best scenario is that the Council, which is not stopped by the European elections, will work on the package and will work on the regulation at least, and by the end of summer they will reach the result that will be the result of the Greek presidency, and that can be taken by Italian presidency in order to start the trialogue. And at the same time, at the end of summer or early autumn, the new Libe committee, or whatever committee it will be, but the committee of the Parliament will decide, let's take all what was done in the last term and let's follow with it. But as I said, it's very doubtful. The worst scenario that may happen is that the Council will not reach agreement as it did not reach last few months. So the deadlock will continue also until the end of the summer, which for the parliamentarians will mean, well, we should rethink what we did in the previous term. So it means let's at least open the discussion again and have these 4,000 amendments again on the table and try to work on it again, which means that we will not have the new framework by 2020 probably. So these are the two scenarios that I can draw, and unfortunately I have to say that once we are losing the allies of the regulation, the second scenario is more and more possible.
And I think the context of this debate might also be given the NSA revelations and the spying and surveillance as well. And this has kind of put some pressure on some of the EU, US data agreements like Safe Harbor. I was wondering if Mr. Nemetz could kind of comment on that. I mean, there seems to be, well, I think everyone can kind of agree there's loads of loopholes. There's quite a few loopholes in this agreement. But it seems like the Commission, even though it has given some recommendations, is still very hesitant to scrap it altogether. So what needs to be done by the Americans for the Commission to say, wait a minute, this has gone way too far. We need to scrap this.
First of all, I think for the trade negotiations with the United States, the fact that the regulation is not concluded is a huge burden and uncertainty. Those who want these negotiations with the United States to be successful, I think have a strong interest to make sure that the regulation is concluded this year. And certainty on this subject is created and trust is coming back. Because alone with the safe harbor, for example, we will not be able to recreate the trust the digital industry needs, and in particular, of course, also the American digital industry in Europe needs. Now, of course, we are not claiming, and nobody says this, that the regulation solves all issues in relation to the NSA. Obviously not. But the regulation and the ability to agree on it between member states is an important signal politically that in Europe we are able to hold privacy high. It contains important rules which, let's say, make the life of an all-saving, all-looking, all-grabbing Secret Service more difficult, in particular when Secret Services rely on transfers from private parties, which is, of course, the business model of the US NSA. It's the combination of public power combined with private enterprise, which is the uniqueness of the US NSA model. And I think, as Vice President Reding said, the revelations were a wake-up call also for those, and many of those actually, who previously had problems with the regulation. They were woken up, and it is true, the analysis which you have made, that in the Parliament in particular, many people have rethought their previous positions, and they have understood the wake-up call. So I think the most important signal to the United States is, and actually to the world, whether in terms of business or individuals, is, are we in Europe able to continue taking the lead on defining what privacy is about and how it works? Are we able to equip our data protection authorities with better instruments? Or are we going to continue to fine Google 150,000 euros? You know, I can only say this regulation will not be perfect, but it will provide more instruments to the DPAs. It will provide more instruments to individuals. It will ensure a higher coherence of application of law. It will not be perfection, but a higher coherence of application of law through the fact that it is a regulation, not a directive. A directive, as the initiated know, always leads to divergences of already by the first stage because member states implement directives differently. So the fact that we have a regulation plus a coherence mechanism, and again, even if it's a coherence mechanism which is not perfect, combined with a regulation, it will be better than the situation we now have with a directive. So what I'm saying is, what is on the table now in the Parliament and in the Council is a good basis for the two institutions to talk to each other and to come to a result which certainly is better than the status quo. And those who are asking for more, they take a high responsibility on themselves because they may contribute to failure. And those, like the privacy officer of Google, who go out and say this regulation is dead, well, they have a policy agenda. They want it dead. That's not scientific analysis, that's political propaganda.
Okay, I think Mr. Philippos wants to step in here as well on this.
So I totally agree with Paul's analysis that this regulation has to be passed because of the externalities. The US has been an important delaying influence on the regulation. That's absolutely clear. And we have now the transatlantic trade negotiations, and we are being reassured by the Trade Directorate of the Commission that data protection will not be part of it. But perhaps some of you know, for example, that 2 US senators introduced a piece of legislation in December in the Senate called the Digital Trade Act, which has some specific provisions to mandate to the US trade negotiators to make sure that the trade negotiations include provisions for free data flows, including interoperability, and I quote, interoperability between different data protection systems. So there's clear a matter of urgency for this regulation to be passed before any such law is passed in the US and before the trade negotiations progress. On the matter of safe harbor, we believe that it's not going to work. The 13 demands that the Commission made are probably not going to be implemented simply because the FTC doesn't have any sanction powers, doesn't have remedy powers. I mean, for example, yesterday it announced and revealed 12 companies that do not respect safe harbor, but it cannot put sanctions on them. I think it's put the matter for public consultation. And I think abolishing safe harbor will put pressure on the US, for example, to implement the Obama Bill of Rights, which was issued in 2012 with promises of a general privacy law in the US as well. And that's actually the demand of my colleagues in the US as well. Mark is here, maybe he will want to add during the public discussion something on this.
And I mean, it is interesting because in that respect, when we talk about the US and EU, it almost seems like the approaches to privacy are completely different, where here in Europe it's a fundamental right, but in the US it seems to be almost like a consumer right instead. I wanted to also now perhaps open up the discussion to questions to the audience. And if you do have questions, just raise your hand and then introduce yourself and then direct the question to the person that you on the panel, please. I see somebody here in the front.
Yes, Paul Nemitz, you said the regulation will bring trust, and from my point of view...
Sorry, what is your name?
Tobias Mosches.
And you're from?
From Datenschutzraum e.V., an NGO in Germany.
Okay, thank you.
Thank you. You said the regulation brings trust. For me, it's at the moment a point where I ask myself more and more points are moved, more safeguards are moved under the control of the Commission. And when I see safe harbor under these conditions, where we see all we were afraid of is happening, and no safeguards are working in any way, and even safe harbor is not stopped, or at least threatened to stop, then I ask myself, what will be with the other things that are proposed in the new regulation, where all third country transfer is decided by the Commission.
Yes, on the question of which institutions in Europe benefit from this regulation, it's not the Commission, it's the DPAs, because the DPAs through this regulation will get teeth. We have a number, apart from the Polish Data Protection Authority, we have a number of data protection authorities and ex-data protection authorities in this room. I mean, let's do a round question here. You know, what is the highest fine which has ever been imposed by them? What are their instruments really, and how often have they been applied? I think in terms of the powers and the reality of data protection authorities being able to make a difference in law, this regulation brings what they need to bring them up to speed and to par with national competition authorities. There is no reason why we should be protecting competition between enterprises in a more rigorous way than the individual freedom and the personal data of the individual. So I think, you know, to say that the Commission gains more controls and more powers is a wrong analysis of this legislative process. It is empowering the data protection authorities to make a real difference in the future, and that's exactly what we need in this new digital world. On the second question of the safe harbor, I hear the doubts whether the Commission will be able to work with the United States to implement what we have put out in terms of 13 recommendations for improvements. And I can today take notice of these doubts. I'm myself the chief negotiator with the US on this, and I will do my best, and I am confident that we will be able to implement these recommendations, because my feeling is the people in the United States, they also believe in freedom. They believe in the protection of their individual life, of their identity. Americans don't want to be spied on. They also want their data protected. They are a great country, a democracy with a free press and great individualism. And they have a vibrant civil society and, you know, a working democracy. And I'm confident that when we work together with them, there will be convergence in the future of how we deal with privacy, and the progress of the safe harbor will be the same type of, not only symbol, but reality of this progress as the speech of President Obama of Friday and the policy instructions on protecting privacy, also of people in other countries, were a first step and a clear sign that this is where things are going. There's only one way of privacy protection on both sides of the Atlantic in the digital future, and that's more of it. And I think in America also more and more people, including in the government, are understanding that. And that makes me confident that on the safe harbor we will be able to make good progress and come back with the result against the doubts which are fair to have today.
Do I see any other hands up there? Or yes, here in the front as well, please. So, can you identify yourself, please?
Sure. My name is Mark Rotenberg with the Electronic Privacy Information Center in Washington, D.C., and I'll accept Anna's kind invitation to say a few words about the situation on the other side of the Atlantic. I wanted to say at the outset that U.S. consumer organizations have strongly supported the efforts to move the regulation forward. Last year, 22 of the leading U.S. consumer organizations sent a joint letter to the European Parliament to express our support for the work of the Parliament and the Commission. And to be very direct, we are self-interested. We see the strengthening of privacy protection, of data protection in Europe as a way to improve global privacy standards, to improve privacy protections for Internet users all around the world. So the fact that there has been a delay, a pause, however you choose to describe it, is not good news for us, as I know it's not good news for you. And I think even quietly, the US firms that have pushed against the regulation in light of the Snowden disclosures and what we've learned now about the NSA may actually see a need for greater privacy authority, if nothing else, to ensure that their own networks are secure against the attacks that we now learned have occurred. I'd like to say a word also about President Obama's speech last Friday, which I think in some significant areas signaled a change in direction that's positive. The first key point is that he indicated, at least with respect to the United States, that he would end the NSA's telephone record collection program. And for us in the US, that was absolutely critical because we could not imagine anything worse than an intelligence agency routinely collecting the telephone records of all of its citizens. We had worked to stop that, and the President announced the end of that on Friday. The second thing that he announced was a commitment to implement a majority of the recommendations of the expert panel of the review group that he appointed. And that review group put forward 46 very good proposals with real significance, I think, for global privacy standards, for internet security, for openness, and we support that as well. So I guess the question is, then what happens next? And I think the first observation, which is what Paul said just a moment ago, is that we all have a common interest in moving privacy protection forward. I mean, we live in a global world, we operate on the internet. You know, privacy protection is not just the concern of Europe, it's the concern really of everyone. And so any effort that helps move this forward, I think, should be supported. To the safe harbor issue, if we know now that the protections are simply not working, then I think the wise thing to do is to look more closely at that and to say what needs to be done to strengthen it. As Anna said, not only were we skeptical at the outset, but what we've learned recently confirms many of the worst fears. So we will continue to support the efforts to strengthen privacy safeguards in Europe. It's very important for you, for us in the US, for everyone. I mean, at the end of the day, we really are all in this together. We have a common cause, and we wish you all the best.
All right, thank you. Yes, here in the corner, please.
Hello, I'm from the Danish Consumer Council, an NGO, and Denmark is, I think, a bit of a problem here concerning the discussion regulation directive, because the government in Denmark, they even though they like privacy and so on, when it comes to their opinion, they think on the everyday life, and they want to support the state and the public authorities, and they think it's too much hassle for them to do the privacy impact assessment and too expensive to work with privacy by design. So even though all the consumer NGOs and the Danish industry are together to support the regulation, the government and maybe also the PDO, the Public Data Authority, I don't know, but the government is against the regulation, or we are working still on the issue. But is there a new deadline for the member states to make up their mind concerning this debate on regulation or directive, or what is status? You said from Poland that you're just about to give up. it seems like, are there more member states who are changing their opinion on this issue? Because I was hoping that we were going to have a regulation, even though Denmark is against it. But so I just want to know the status on that issue specific. Thank you.
If I can start briefly, of course, everything what I say is not the position of the government, because I'm not representing the government of the Republic of Poland. I'm just representing the Data Protection Authority, which is an advisor or expert for the government. But I have to say that all the doubts that were so far expressed in the countries are coming back on the table. I'm sorry to say, but we didn't make any improvement in the Council for the last few months. So it means we are exactly at the same position that we were a few months ago, and all the questions are discussed again and again and again. And we are facing the problem that the governments will start to raise the questions they were not raising so far. I was at the meeting with the Polish representative of enterprises, and they started to say precisely why not to keep the data protection law we have at the moment in Poland. We are more used to that than to the new solution. So my term as a data protection authority is finishing in August, and my successor can come to the conclusion that we have to start to discuss again. And if all the topics are still open in the Council, then the discussion will start in the country like Poland again. I'm not going to say in the name of the other countries that were so far supportive to the regulation, but I'm just saying we are losing the last countries that are really supporting the regulation in the Council.
Mr. Nemetz, I mean, do you agree with this, that more and more member states seem to be more reluctant to push forward on this regulation?
I think what we just heard from Denmark is exactly the reason why we in the Commission plead for political level to take charge. Because this is a question of political responsibility. If it is so that consumer associations and industry support the regulation, and in the Council civil servants work in the other direction, well, that is a matter of political decision making. And one has to responsibilize the political leadership if this happens. And I think, yes, it's a complicated file. Yes, we have protracted discussions. But I am convinced that if politicians take charge, they will introduce the judgment, the political judgment, which is necessary to overcome, the small problem discussion here or there. Because politicians know that nothing is perfect in the world, and legislation is the least perfect thing, as we know from Bismarck, who said 2 things people shouldn't know. 1, how sausages are made. 2, how laws are made. So on the question of whether we are moving towards convergence or whether we are losing countries, I am alerted by what I hear from the Data Protection Authority in Poland. I would very much regret it if the political leadership of Poland changes direction on this, because indeed Poland was very supportive so far. My view is that we have movements towards convergence after all, and these movements can be substantially accelerated if politicians take responsibility. But I'm not the only one who watches what's happening in the Council. The Greek presidency is also here, of course.
Yes, thank you. I will have to agree with Mr. Nimitz, and I would like to I'm sorry, but I would like to correct you about your last statement that the last discussions at the DPAs working group were a disaster. I mean, they were not a disaster. I mean, they were not successful. But yesterday, for example, we had a very constructive and very successful meeting on the papers that the Greek presidency presented to topics. We had a very large consensus. This is a sign that we can go on if we try to find the common interests in view of our common goal, which is the protection of the fundamental right to data protection. And what our Danish colleague said, that, for example, the Danish government does not accept provisions putting the obligations to adopt privacy by design things or impact assessments because they cost money, for example. This is an example that these new provisions are provisions that protect individuals. I mean, they are for the good of the people, of the individuals, and also they also give the opportunity to the data controllers to be able to proceed to processing of personal data in a more secure and secure way and under legal certainty. So I think that we all should try to give an effort for this constructive dialogue. And I also would like to say that, I mean, to those who express doubts about the regulation and ask that, okay, we are in such a specific context and there is mass surveillance, there is, I don't know, Google or other companies that do not process our data correctly, and the regulation does not give an answer to that. I mean, my question would be, what would happen without the regulation? We all know and we all agreed that the existing legal data protection regime is not enough to protect the individuals. So
yes.
we need to work on that and to go forward. And if I may just use add a personal touch in my intervention. I mean, when somebody asks me what am I doing in life, and I reply data protection, you know what they say to me? Data protection, but there is no data protection. Everybody is monitoring our communication. Everybody is, I mean, there is not trust in data protection anymore. And we need to give a response to that. I mean, people need to give back their lost confidence in order to go forward. That's my point of view. And of course, I share the best case scenario that you explained to us. And I would like to say that the intention of the Greek presidency is to go on with this best case scenario. Because if not, if we go to the worst case scenario, then I cannot imagine what the situation would be in 4 or 5 years, okay?
Well, we talked a lot about the member states and I suppose not so much about the private sector, but we have 15 minutes left, so I see 2 more questions. If I can get this gentleman here first.
Thank you. Martin Hoskins from Privacy Consulting. Can I just thank the Polish regulator? I think it's the first, I believe you're the first international regulator to come out on record as to declaring that the regulation won't be passed before the European parliamentary elections. But what I found really interesting was why. And you were talking about the failure of the Commission to support its own projects. I even wrote down, you said the Commission should create support in the Council and not on Twitter. Now, does that mean that there is something wrong institutionally or personally with the Commission? Do you think that means we've got to wait until Mrs. Redding or even Mr. Nemix have left the stage before there can be people within the Commission who are able to engage more effectively with member states in DPAs? Where can we go forward? How can the Commission change its spots so that it can try and deliver something that we'd all like to see?
Well, I guess everything which was to be done about the political will in Europe has been done. The statements from Vice President Reding and from the members of the cabinet of Vice President were showing the things that Paul has just said a few minutes ago. It was said precisely, but it didn't reach the final on 6th of December. So on 6th of December, the answer which I heard from the member countries was, well, we will not have a political will without having the legal text. And I agree with Paul that political will is crucial. The problem is that the Commission did everything they could with political will. What we have the problem with is an explanation what was actually the legal text to be achieved. And that's something which, well, in my opinion, was not done correctly, and which I also blame myself not being able to do it correctly, because I didn't have the enough support in understanding what is really the role. Because if you think about the general principles, I absolutely agree with what was said by the Commission. Also about the things about DPAs not having enough possibilities to perform the duties. Of course, I will say it as well as a DPA. The problem is that right now the problem is the text, not the political will. The political will not come without the text.
This gentleman's been waiting here for some time, and then we'll go to a lady in the back.
Well, Peter Schaar, I'm from the European Academy for Freedom of Information and Data Protection in Berlin. Well, I completely agree with Paul Nemitz's assessment that it is a political question. But if we agree on this, we have to ask, what is the political question? This is not only limited to the substance we discuss. It's also the question of powers, it's a question of competences, and from my perspective, much of the criticism against the approach of the Commission that is coming from the member states is against the giving away competences in the legal field as well as on the practical field. In the legal field, if there is no space for legislation in the member states, the competence goes to the European Parliament, the Commission and the Council, and therefore the influence, the opportunities to influence the procedures are weaker from the national point of view than today. This is one aspect. And the second is the role of the data protection authorities. The increase of the independency of the data protection authorities might be seen as a threat by some governments, because if there are strong data protection authorities with real powers, they are not dependent on the decisions of the government, and if they act in a different way, that might be a problem for the governments. And I think these are two crucial issues. On the first one, I think there could be a solution, at least if we focus on the main issues in the regulation. Perhaps there might be a third scenario, not only the both Wojciech mentioned. Perhaps a third scenario might be to focus on some main issues and to start again, perhaps, with these, or to continue with these issues. Not every single article and paragraph of the whole regulation, perhaps, is as necessary as every other. So we have to focus. But this is not the time to do this today. I think we try to support the Parliament and the Commission in being successful, and we have to try to convince our governments. But if we fail, we have to avoid that would be a complete failure. So, but at first, scenario A for me is we need the regulation. And perhaps we have to consider a scenario B after the election of the European Parliament and after the end of the Greek presidency.
All right. Is this, anybody want to comment on that, on this?
I think what Wojciech has said, namely that the Commission has made before the argument that political wisdom and political judgment has to be inserted in the discussion is right. But, you know, sometimes one has to repeat the same argument over a sustained time to convince, because, you know, things have to mature. And if the technical level comes back once and says there's still huge technical problems, Minister, and comes twice and 3, 4, 5 times, well, you know, sooner or later, the political level will see, you know, is this technical judgment really what I want? So I think the likelihood of politicians taking charge increases over time on this file, so I think it is right to again call on politicians to take charge. We have a council, an informal council in Athens this week, where ministers have received good questions from the Greek presidency, and I think this council, this informal council, is an opportunity for ministers to show that there are issues on which member states can largely agree. Incidentally, this is about international transfers and the application of the regulation to companies which provide services from outside of Europe. And I have some hope that the Greek presidency, with its great skill, will be able also to turn a little bit the mood and the attitude. And in the sense that ministers go home and see, hey, there are things on which we can agree, and that also injects into the work of the very knowledgeable experts. I think it's an issue a little bit also of attitude and of willingness. We have too many people, or let's say we have some, who go around and say quality before speed. Sounds great, unless it is instrumentalized to stall. So I think we have to look a little bit at the attitude of people and call on, let's say, a constructive readiness to work within corridors of what is reasonable.
Ms. Felder? And if we can kind of wrap it up.
So I would agree a lot with the analysis made by Peter Shah and the colleague from the Greek presidency. Okay, 1 second. So on balance, it's better to have the regulation speedily than not to have it with the probable consequences. One issue hasn't been mentioned in all this political will. You know, one of the biggest countries that is currently delaying it is actually Germany, if I'm not mistaken. Perhaps, you know, it should be pointed out to Germany that, you know, 82 million people, their data is leaking out through countries where the data protection regulation legislation is weaker than it is in Germany now. For example, Ireland, that could be an incentive. So on balance, we would want the regulation to pass speedily.
And I think we have just one quick question, and then we need to wrap it up really, and to have the conclusions. So I see a lady back here who's been waiting.
Hi, Julie Cohen from Georgetown Law Center. So from the perspective of an American observer, there is one aspect of this conversation that has just been bizarre. We have very inadequate data protection regulation, but we have fairly robust practices surrounding transparency, particularly in regarding the access of lobbyists to government. And I haven't heard it discussed at all, except in sort of masterly indirection. It was curious for me to see several months ago that there was a front page article in the New York Times about how all of the major US government relations law firms, aka lobbying firms, were opening offices in Brussels, and that they were under no obligation to disclose their client list or the amounts of monies being spent on lobbying. And particularly for someone who follows data protection issues, it kind of sets up the commission as this black box, and you don't know what's going into it, and you know what's coming out of it, which, well, that's been discussed. And I really am left very unclear after listening to this panel whether it's just impolite to discuss that in public, in which case I'm being impolite right now and I apologize, or whether nobody knows how to discuss that in the context of the process that we've been having, but it really seems to me that something does need to be said, and I would like to ask those of you who see fit to respond. Thank you.
Do we have time? Well, all right.
Just one. Yeah.
I think there are a lot of things we can learn from the United States. And enforcement by the FTC is one thing, holding out fines of 20 million, 30 million on privacy, non-compliance to Google and Facebook. That's something no European DPA can do now. And Julie Brill, the commissioner of the FTC, once said the best for privacy would be EU rules and US enforcement. So I think, on enforcement we can learn. What you say on transparency, I think, is also a very valid point. European democracy, for Europe as a whole, is much younger than democracy in Washington. We only have a directly elected parliament since 1979, and I think there are a lot of things we can learn in the positive and in the negative from Washington. On data protection specifically, we may not have the good transparency rules. It's not my field of expertise. I can only tell you that I'm asking all my collaborators to take a good log of the time they spent and to make sure that it's not uneven. And I personally would be in favor of logging much more, who sees whom in the European Commission, because I think, that is an issue. But on data protection, please go to lobbyplug.eu. It's a private initiative, which in a fantastic way creates transparency about the impact of lobbyists on creating amendments in the European Parliament. On this website, you can track from the letter of Amazon, Facebook, Google's and the likes, right to the amendment presented in the Parliament. It's a fantastic thing of transparency, and I'm very proud that we have it. It shows that also Europe has good free speech and good activists, and it was a very useful contribution to the debate and to the preparation of the European elections.
All right, thank you, and I think Christopher wants to have some conclusions.
Thank you. I was going to make 3 comments, but we've handled the stuff about lobbying and the outside interest, so I'll just make 2. The first thing that's come out very strongly from this is the problem of understanding the legislation, both for normal people and, it appears, also for the lawyers and experts in the institutions. And we forget, as privacy experts, how complicated this stuff is and what a challenge it is. And in a way, this folds in with the fact that the FRA will be launching their report on legal redress this evening, that apparently, according to the FRA, if you go to a lawyer, the lawyer won't know about data protection, and if the lawyer does get you to the court won't know otherwise. So there is a real challenge, the first conclusion, to explain data protection outside our community, both in the legal profession and to normal people. Then, with regard to the speed that this package is going to go through, what we've learned is that there are 3 conceivable options for timing: before the Parliament goes down, before the end of the year, or sine die. I must say, personally, I have not understood why, if we've been working on this nominally full-time since January 2012, that's 2 full years, we haven't made more progress. And with respect, I think that the truth is that in the Council, some member states have started their intensive work very late, and the deep-seated reservations that others have about various aspects are only now starting to come out. And I would underline, that's been mentioned today, the use of a regulation which would override national law, the coverage of the public sector, giving real powers to DPAs. So my second conclusion is to agree with the speaker who said that what we need to do now is focus on some critical issues that will enable us to make progress. For example, with regard to the use of a regulation, which is absolutely critical, we have to provide a double reassurance to the member states The countries like Germany, which should be pushing this forward and are not, that we should be taking the lead, they have to be reassured that this will not reduce their standards. And to other countries like the UK that are worried about the economic aspects, at the same time, they have to really be persuaded that it's better for business, as we heard in the panel this morning, to have one law across 28 legal regimes than myriad 28 national ones. With that, I'd like to thank the CPDP for organizing this panel. I'd like to thank the panelists for their very frank views, and I'd like very warmly to thank the moderator, Nikolaj, for running the debate. Thank you very much.